morning. Happy New Year.
Happy New Year. Good morning. Good morning.
Commissioner Giraldo, you're on mute.
Good morning, everybody.
Good
And Happy
morning.
New Year.
We were, Commissioner Giraldo, I have to
This
tell you
conference
that
will now be recorded.
the staff and I were discussing your necktie.
Oh,
And we like it, but we were noticing that it wasn't a bow tie.
Good morning.
not today, no.
Good morning, Madam Shanice.
Good morning, Madam Vice Chair, Mr. Chairman, Mr. Giraldo,
Good
Good
morning.
morning.
and Madam Council, Delisa.
Yes, good to see everybody.
It is good to see everybody.
Yeah.
Do we have Commissioner Dorner joining us as well? Okay, yeah, I think we are expecting him, so let's just give it one more minute.
And good morning, Mr. Hunt. Make sure I have equity in my greetings.
Don't forget, good morning and happy new year to you all.
Happy New Year.
And we had Director Checkley for a second, but she abandoned us. She'll come back.
He bailed.
Hail.
Good morning and Happy New Year to everyone.
There
Good
we
morning,
go.
Madam Director.
Thank you.
So, show of hands, how many people actually stayed up to midnight?
I did.
I did.
Yeah. Okay.
I was awake. I wasn't up, but I was awake.
I guess that's fair. I was actually up, but not right. Yeah. Okay. There we go. There we go. Commissioner Dorner, Happy New Year.
Happy New Year to you as well.
Uh-huh.
Happy New Year, sir.
Happy New Year.
All right. I think we are all here and present. We are recording team. We're ready to go. Okay. Good. Good morning, everybody. The time is 10:02, and I will call the January 5th, 2023 Planning Board meeting to order, the first one of 2023. Happy New Year, everybody. We have an entire complement of commissioners are with us. We have Vice Chair Bailey, Commissioners Washington and Dorner, and Giraldo. I'm Chair Shapiro, and as we move forward to the business at hand, please note that the deadline for all participant pre-registration for all submission of materials and exhibits was 12 noon on the Tuesday before this planning board meeting, which is shown on the screen and posted on our website. You can see it on the screen in front of you. Registered speakers may join the meeting with the link provided in the email provided by the planning board office or listen by phone by utilizing the call-in number provided in the email. And of course, anyone may tune in to watch the planning board meeting live via live stream. And if you wish to speak or become a person of record, you may use our online web form, which is also referenced on the screen before you. In addition to the commissioners, we are joined by our planning director, Director Checkley. We also have Delisa Coleman, our associate general counsel, and Jessica Jones, our planning board administrator. Joe Parsons is our senior technical hearing writer. He's with us as well. And James Hunt, the division chief for the development review division, is joining us as well. We're also supported by Kenneth Flanagan and Ryan Cron, interrupting us with technical issues behind the scenes. Thanks to them all. And once again, Happy New Year to everybody. So our first item was item 2. I'm looking for a motion to approve the draft minutes of December 15th, 2022. Is there a motion?
Motion to approve, Mr. Chair.
Second.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Giraldo. Is there any discussion on the motion? Seeing none, I will call the roll. Vice Chair Bailey.
But I.
Commissioner Giraldo.
I vote aye, Chair.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Next item, which we have a number of sub-items to this item. We're going to go to item 3A, legislation. So we have 1, 2, 3, 4, 5, 6, 7 items that we're going to be discussing. And we have Ms. Hightower, who will be helping walk us through those. Why don't we take them one by one? Ms. Hightower, take it away. Actually, before you take it away, CB12, we're going to CB12 and CB. What's the other text amendment one right here? 16?
No,
No, not 16. 17.
it's
So
12.
CB12 and CB17. Let's do those in that order, just because they're. I'm not even sure why CB17 isn't included in CB12, considering what the council is considering doing with CB12. So, Ms. Hightower, if you can talk about CB12 and then CB17, that'd be helpful. You're on mute. Ms. Hightower, we can't hear you. You're actually not on mute, but we can't hear you. So take a second and.
17. Where is 17? Oh, I see. Okay.
Can you hear me now?
Yes.
Yes.
Yes,
Come in. Come in. I'll put my mask on.
yes, we can hear
I
you
don't
now,
know
Ms.
what the
Hightower.
problem is. Hello?
We
Can
can
you hear
hear
me?
you. Can you hear us?
We can hear you.
Randy, you can hear us? So we
Good
can
morning,
hear
planning
you,
board. You can hear me now.
and you can hear us now.
Yes, I can. Thank you, Ryan.
Thank
I'm
you, Ryan. So
sorry.
we are good to go. So again, we're going to be taking up first CB12 and then go right to CB17 because that is the complement of text amendments repeals that are before us.
Okay. CB 12 repeals 18 site-specific text amendments enacted under the old zoning ordinance by previous county councils. These text amendments will no longer be allowed to use the transitional provisions within the new zoning ordinance. The planning board in the past has opposed many of these site-specific text amendments because they reduce the uniformity and consistency in the zoning ordinance. On December 12th, I'd like to tell the board that the county council adopted CR 5 2023, which suspended these prior enactments because they were inconsistent with what is determined as county policy now. Staff recommends that the bill be amended to reflect the correct drafts of each bill, each of the bills that are affected by CB 12 2023. Staff recommends that the planning board vote to take no position on CB 12 2023. Thank you. That concludes my presentation on CB 12.
Thank you. And again, we'll get to CB 17. Bear with me. CB 17. We'll get to that in a bit, but that's the other outlier text amendment repeal that I guess it could have been on the CB 12 list because it's just another text amendment they're repealing. So, commissioners, I'm curious to see where you are all with this, and we have the staff position, staff's recommendations to take no position. They have some amendments as well. My view on this is not all, but most. I think that we did some crunching of the numbers, and I think of the 19 of them, I think 9 of them, Ms. Coleman, maybe you have this or maybe you don't, but I think 9 of them we had opposed in the past. I think 5 or 6 of them we had supported. I think 4 of them we had taken no position. So it's all over the map. My concern is less around specific text amendments that we have typically, we are not in support of anything that it comes close to spot zoning, to site-specific text amendments. And I think that we've been fairly consistent with that. The problem I have with this is around the process, which is this is a whole lot for us to digest. Again, we're talking about 19 text amendments. And then there's a question for me about, well, why these 19? There have been a lot of other text amendments. And so I'm trying to understand the rhyme and reason of this. And then I'm also concerned about what the message that it's sending to, the development community and the public at large around what could feel like the arbitrariness of doing all this in one lump approach. So if there's specific text amendments that the council is looking to repeal, and if we want to consider those, I think that's a discussion worth having. So that our own staff has suggested that they're taking no position on this. My view is, given the process, not so much the issue around whether or not we like text amendments in this way. Some we do, many we don't. But more, when you're putting it out as 19 of them, I don't think this is a very healthy process. And I think we, as the planning board, can speak to our concerns about the process as well as anything specific related to text amendments, the substance of any of the text amendments. So that's a long-winded way of saying, yes, the staff is taking no position. We can do the same thing. I would also be curious to see where I am at the moment is actually to not even take no position, but to oppose these repeals and do that on grounds of looking for a better and healthier process. So that's where I'm at. I just wanted to frame that, but I'm curious to hear where you are, colleagues, with this as well.
Mr. Chairman, thank you for your comments, and I guess I am similarly aligned. I was quite surprised to see kind of an omnibus approach to text amendment repeal, and I was also surprised that staff took a position of no position, especially given the other pieces of legislation that we're about to go through. I think just omnibus in general first, I'm most familiar with that in the context of fiscal policy, but it limits opportunity for debate and scrutiny, and arguably, kind of anti-democratic. I mean, to your point, how do you take all of this as one lump sum and not deal with them specifically? And there may be some rational categorization for these 19 text amendments. And I also had a clarifying question for staff. In your memo, Ms. Hightower, you indicate that your rationale for not taking a position is the reduction in the 2-year period, which is a policy decision, which I certainly don't disagree with. And in the text of the legislation, I'm on page 4 of the actual bill. It says development proposals. It cites 3 specific zones: LCD, LMXC, and LMUTZ. So do each of these 19 amendments, do they fall within those zones? I'm just curious because I don't think that, well, let me not presume, I just want clarification. Where exactly is it reducing the 2-year period, and specifically for what zones? Is it those three zones cited in the legislation or others?
No, ma'am. That is already existing language within the zoning ordinance and
Right.
is not impacted by this legislation. Some of the zones, let me let you
Well,
speak.
no. Yeah, because exactly what you said is exactly my understanding. But in your cover memo, under policy analysis, the 3rd paragraph, last sentence, it says reducing that 2-year period is likewise a policy decision for the council, and therefore staff takes no position on CB12, which
Ms.
I read.
Ms. Hightower, let me jump in here real quick, please, if I may.
Yes.
So all of these text amendments were not carried forward into the new zoning ordinance. But everyone in the county was given 2 years to use the old zoning ordinance. This piece of legislation would take that away from the individual properties that benefited from these text amendments. So that's what we're saying, is that that was a policy decision by the council that everyone would get the 2-year window. And if these text amendments are repealed, then these particular people are being treated differently.
Yeah, and see, I have a problem with that. I mean, and I guess I would be more aligned with the chairman's comment to oppose, because at least for me, I did not see any articulation or rationale as to why that would even be appropriate, other than seemingly, just someone's opinion, and not kind of fact-based, if you will.
Well, there's
Thank you.
nothing in the bill. There's not, and that's why staff took the position that we took.
Okay, thank you for that, because I was searching for what didn't exist, so I appreciate you affirming that. So those are my initial comments, Mr. Chairman.
Thank you, Commissioner. Other comments from commissioners?
Yeah, I reviewed the changes, and I guess I have a couple of comments. The problem I have with opposing in general is because some of these may be positions that we've opposed before. And so I think we need to be consistent. And if we've opposed them before, I think we should maintain that opposition. And I guess the middle ground for me would be what the staff has recommended, to say we just don't take any position on it at this point. I agree with the process. I think it's overwhelming to have one bill and have all these changes. Another thing that I need a little clarification on, part of my hesitancy is that I would hate to see developers have relied upon this and taken some action on that 2-year window, in which case it would be, and I agree with you, Mr. Chair, that it would be arbitrary. But it seems to be that what the council is trying to do, or at least the way it was framed in here, the policy analysis, is that would eliminate the ability of new applicants. So if somebody simply has the land but has taken no action up to now, based upon that 2-year extension, are they really harmed? Now, if a developer has in fact relied upon that 2-year extension and has taken action to develop, that's a separate issue, and they would be harmed. So I can't go with the opposition to the entire thing. I can go with, I feel more comfortable taking the position of the staff on this, who probably have had a lot more time than we did, at least that I did, to study each of these provisions.
Thank you.
I'm sorry. Go ahead, Mr. Chairman. I was gonna.
No, it's fine. Vice Chair Bailey, Commissioner Joyner, anything, or do you want, I think Commissioner Washington wants to address something Commissioner Giraldo was speaking to as well. Is that all right? Why don't you take it away, Commissioner Washington?
Yeah, Commissioner Giraldo, I guess opposed period is not what I'm saying. Opposed as drafted is kind of where I am. And then the letter would articulate our concerns, which are more procedural and of a process nature. I mean, just by virtue of this conversation, because I think that the council, and they may not be as, well, let me not be presumptive, but I think they would likely hopefully appreciate our insight as to why, taking an omnibus approach with these type text amendments is not necessarily the right way to go, and just procedurally it creates some potentially confusion. So I guess oppose as drafted is kind of where I'm netting out.
Okay, thank you.
Mm-hmm.
Mr. Chair, that was kind of what I was looking for. I didn't want to outright oppose, because some of these we obviously have taken a position on previously, but oppose as drafted would support my thinking on this particular item.
Thank you, Vice Chair Bailey.
Mr. Chair, if I could add just one more point that might help explain better staff's position here.
Take it away.
Okay, so these are 19, and they were approved between 2018 and 2021. The planning board opposed 13 of them, took no position on one bill, and supported 5. So that adds to why we're saying, what we're saying, because, it's just, if we support it, then we're going in contravention to what the board did previously. If we oppose it, we're in the same spot.
Right.
Right.
Is it, Madam Director, oppose is, what are your thoughts about oppose is drafted and then articulating in the cover, it's more of a process concern as the rationale for our position in that regard?
We can certainly do that.
Okay, and that would not be inconsistent. We're kind of a rhetorical, that's, to my mind, that's not inconsistent with where staff is necessarily, right? And
Yes.
for the positions we've taken previously.
Correct.
Okay.
Thank you. Thanks for that. Well, Commissioner Dorner.
Yeah, so I didn't have a ton of time to review this because I didn't know we had a dozen bills. Because the agenda that I saw had 0. And we had 1 in the backup. But I did glance through this in like the 40 minutes or so that I knew about them. I would say that we should take the position of partially opposed, but including, I think, the language of like how we stood on the other ones, because the 5 that we approved or that we supported before, not approved, those would be ones that we would be opposed to actually removing, and the other ones we may be fine with sticking. I'm not concerned about the process of including multiple things at once. That's the prerogative of the council, and there are several people there who are supporters of the bill who are veteran council members for multiple terms. And if that's how they want to do it, that's how they can do it. I would just suggest the partial opposition inconsistent with what we had opined before about not removing the text amendments for the ones that we had supported. However, in the bill, I'm not clear sort of in the rules. Like, I really don't care if that much of like, there's not a 2-year limit. Like, why is 2 years like the right thing? Like, I don't know. If somebody hasn't acted in 2 years, that's a long period of time. And if they want to reduce it to 6 months or a year, like that's fine. I don't really have any strong feelings towards that. And I agree that there's the potential for sending bad signals to the development community. However, there is language in here. I don't know if it's the right language, but there is language in there about the new applicants. And it says that unless an application for development is already filed and accepted and or constructed, the following enactments are ineligible. So that would mean that anyone who's taken any sort of like direct action to that extent is fine. They still have the vested right to go forward. Where I have issue with this bill is I don't know if that's the correct language. I don't know when we should necessarily give the appropriate vested rights on text amendments. Like if you raise the land, is that enough to kind of like get the vested right? If you've gone through our planning board process and you've got all the way through DSPs and you have all of the applications in, is that enough of a right? According to here, if an application is already filed, I would assume that even a PSP would be sufficient for that, but that's not clear. So I don't know if we have to do a PSP, a DSP, and everything else, because it's just logically not consistent when it says and or constructed, because if it's already got the applications, then that's the first order just of logical progressions that like if you've done PSP and if that's the sufficient bar, then you have the vested right. It doesn't necessarily need to be constructed, because if it's already been constructed, then by default, you already had the applications in. So just like the procedures of how this goes from like a legal timeline of gaining those vested rights is, to me, not clear. And in fact, it's contradictory just in that one sentence that they're trying to cover for new applicants. And I think that's going to be a huge legal challenge that they're going to encounter. They're going to be in court for legislation on when does the vested right occur for these potential applications for people who are not new applicants but are existing ones and may not have met maybe they didn't construct it. So then there's a question about whether or not they can do it at that point. Or maybe they haven't done the DSP, but they did a preliminary site plan. We just need to make sure that the rules are clear for there. And then at that point, like I would be fine with it. Like if that's how the council wants to do it, I may not agree with like what text amendments they're putting in, but as long as they're creating clear rules for the development community and they're not stopping people like mid-procedure in what before would have been considered to be sort of a vested right and ability to go forward, then I think it's okay. It's not necessarily sending a chilling effect to the development community, because land purchase and acquisition and all of that is speculative. And if somebody was intending on using it but hasn't actually filed an application or done anything from there, they don't have a vested right, and that's pretty strongly and consistently been ruled in land use regulation in cases. So I don't think they're necessarily doing anything terrible in some of this, but it's not clear to me like what is the difference between a person or a development application or a developer that has the ability to move forward and doesn't. And I think that's really where my issue is. It's not in the process. It's more in just sort of the clarity that they're not sending, because it's just plain contradictory in that first sentence right there. And I don't think that's where what they understand. I think that's where they're going to fall flat on their face when they get into court and they get challenged about what they've done here. I don't like text amendments, and I'd rather get rid of all of them. But to the extent that we have them or don't have them, I want to have clarity about the legal times that they're actually vested and able to go forward.
That's very helpful. And I, for what it's worth, as I hear you talking, I associate what you're saying with what Commissioner Washington was saying as well. Even if our interpretation of process may be different and we have different parts of the process that we have concerns about, I think what I'm hearing from all of us, including myself, is there are lots of different versions of this process that we have concerns about. So that feels like in that way we're aligned, and we can find a way to articulate that. We can ask, with staff's help, to articulate that to capture all the different ways that we have concerns about, process.
Yeah, you could say some commissioners expressed concerns about putting up multiple bills at the same time. Others were not necessarily concerned with that, but were concerned with the point at which the vested right actually takes place for development.
Right,
And
exactly.
that is good, like, we're not even on board with our opposition to this because it's kind of a confusing matter in multiple ways.
Right, and I think that's the way to do it. I think that's why we oppose this as it is before us. And I think we can put in the nuance around, we recognize that a number of these text amendments we had opposed in the past. But again, to bring in your vesting issue as well, even with those that we've opposed in the past, because there is a bit of a promises made, promises kept thing that I think needs to be rolled into here as well. So I think for all of these complex reasons, I would encourage us to oppose this for all those reasons, and then staff can work with us, with me, and capture what we've discussed here to reflect the nuances of this.
Yeah,
Is
but
that
we might,
for everybody?
the clarifications, at least under the stuff that I was mentioning, we might want to mention to the county council when the zoning ordinance was effective, or when these different points, like the earliest stage at which it was. Because if it's been a year window for some of these cases, or a 2-year window even, then the argument is not like they already haven't taken action within a 2-year period. So to say new applications is just logically inconsistent there as well. And I didn't go through and look at like the timing of that, but that would be helpful, I think, to do.
Yeah, so we'll work with staff to sort of now, and there's a very quick turnaround on this, but which is part of the problem. We'll work with staff to capture the nuances of all this. So if I'm hearing correctly, we are aligned around opposing as drafted, and then in explaining our opposition, we'll capture the nuances of all this conversation with all the different facets.
Mhm.
Director Checkley, does that make sense to you? Okay. Okay, any further discussion on this? If not, I would look for a motion.
Mr. Chairman, I move that we oppose as drafted CB-12-2023 DR-2 and ensure that staff incorporates in the transmittal memo the essence of this discussion with regards to process being the broader label for the items we put forward.
Second.
Thank you. We have
I
a
was
motion by
wondering-
Commissioner Washington, a second by Vice Chair Bailey. Under discussion, Commissioner Giraldo.
Yeah, I think we need to I agree with what Commissioner Washington stated. I was just wondering whether or not we should have a comment in there. Ms. Checkley put a comment in there, is that we're the positions that we've taken before still stand. So that we have.
I think staff can reflect
That's
that.
all.
Yeah, I think staff can reflect that. I think it's helpful to note, Commissioner Giraldo. And again, I would nuance that with the whole question around the vesting period, because even if we took a stand on a text amendment from a few years ago, we might be in a slightly different place, depending on where they are in the process.
Yep.
So we have that nuance.
Mr. Chair, just on the issue of vesting, that was another reason for staff's position, because just because something hasn't been filed as of to date does not mean that money has not been spent by the property owner, because there's a long lead time up to filing, where they're getting their plans together, they're dealing with stormwater management, they're spending a lot of money prior to filing. So that's why we were like, this was a policy decision made 2 years ago. More than 2 years ago, people have relied on that, and we don't know where they might be in the process.
So,
Understood.
Ms. Sheckler, let me ask you a legal question, and draw on your former life of that. When would we then consider to have some sort of investment? Because at some point it's risk. There's always risk we have Mr. Warner on here as well. At some point we have just the risk of land acquisition when you're trying to combine parcels and split them and just get them rezoned and stuff. And we wouldn't necessarily say that somebody has any right to develop under certain standards or any assumption of doing so. Until they get to a certain point where they actually becomes administrative or procedural at that point. So I do agree that, yeah, people are going out and trying to do permits or different kind of like workups with DPI or other places. That shows some action going in that way. But if someone's just having just talking sessions with a community and asking them if they think it's good, or they're just looking around and asking, hey, would you buy it under this right and maybe develop for us if we can go ahead and get this sort of zoning or these things in place, I don't think that's necessarily the point at which they have a vested right. So if we communicate that to the council, they may ask, well, okay, then when do we get that vested right? Or when do we do that? And we need to be consistent with other cases and how we would consider that. So what would be our position on that in terms of what we would want to see to distinguish between a new application that would not be okay versus existing applications that or maybe existing developers that have taken some kind of minimal effort towards that? Where's that sticking point?
I'm gonna let Mr. Warner get into the nitty-gritty of this, because vesting is actually a technical term, and there are court cases that have determined what real vesting is. But essentially, if the council puts it in the code, then they have that right. But I'm gonna let Mr. Warner say it correctly, because it's been a minute.
Right, David Warner, Principal Counsel. Thank you. I think there's often confusion because the term vesting means different things to different people. But what Ms. Checkley is referring to is the judicial doctrine of vested rights established over many years through Maryland courts and courts all throughout the country. Basically says, once someone has done enough, you can't change the zoning on them because it's not fair. And so they use the term vested rights to determine how much have you done so that we can't change the law on you and negatively affect the money you've put into the project, the time you spent, that kind of thing. Well, that's very specific in Maryland law. They say you get a vested right against any future changes to zoning if you begin construction and have footings in the ground.
Right.
Easiest way to put it. That's what the courts will say gives you a vested right. You can't change the zoning on me now. because I've done that much. Now I look at this bill and I think that the vested rights issue may not be a concern, because if I'm looking at it correctly, and I'm in the same boat, haven't had a chance to examine it in depth, they're allowing even the filing of a mere application to exempt you from this law. So they're saying even before you get footings in the ground and do construction, if you just file an application, we're not going to apply the law. So I don't think vested rights even comes in. I think what Mr. Dorner makes a good point when he's like, what application are we talking about? Is it a preliminary plan? Is it a DSP application? Is it a final plan? Yeah, that application's not exactly clearly defined. It doesn't appear. But all the other issues you talk about are policy issues, you know. Some of these laws have been in place since 2018. So one could say, hey, you've had 4 years to develop under this text amendment and you still haven't? Why are we still waiting around on you? Other people have more recent text amendments. So those are kind of policy decisions, but those are separate from the term vested rights, which we should be careful to throw around, because it's really more of a question of like, how much reliance should we care about however we craft this legislation? Should we care that you've spent a lot of money, but you haven't filed your application yet? You know, or should we base it on time? A lot of policy ways to go about it, but vested rights is kind of a unique term under the law. And I think we should confine our discussion more to kind of what's fair policy wise, because it doesn't appear the council is concerned about violating anyone's vested rights as that term is interpreted by the courts.
Okay. So I just want to, let me, Commissioner Dorner, one second. I just want to frame where we are. So we're still under discussion on the motion that's before us. And I do want to say this is part of, for me, part of the complexity of what's before us. You know, we're right now engaged in a full-throated policy discussion about what's the best way to address these issues. And our council and our planning director and even us, we're all over the place with saying we're not even sure we have anywhere near enough information to have this discussion right now. And I think that speaks to why the position that we're taking on this bill that's before us is so helpful.
Right.
Because really all we're doing is responding to this piece of legislation that they're presenting. And we don't have enough information to support this. I think that's where we're coming from. So let me stop there, turn back to you, Commissioner Dorner. We're still in discussion on the motion.
Yeah, so I don't disagree with that. And I appreciate Mr. Warner's clarifications of things, but my issue is that it's not clear that it's the application. It says and/or in the legislation, which to me, I read that mathematically, that it could be either you've constructed it or you've done the application or you've done both. So to me, like the point at which they get the exemption or that we potentially run amok of like their feeling of being able to proceed forward in this is not clear. So the exemption needs to be at the lower level of these things. Like if you already constructed, you already have presumably applications in.
Yeah.
Otherwise you can't construct if you don't have the applications, because then you're not going to get a permit and you have an illegal usage that you're actually constructing on. So I think the legislation needs to be clear that if they want it to be at the point of construction, which would be then at that point of having the vested right and not run issue with like a takings, then we can do that. Or if it says the application, then we can do that, but we don't have both of them in there. And particularly this is going to be completely inconsistent across cases, and some of them have different starting points. So if you say and or, then you could have one case where you have a text amendment that a developer is running forward with that they've just done an application. You could have another one that's actually gone through almost through construction, and there are different phases of it. And then depending on the interpretation of whoever's reading this document in DePi or wherever else that's trying to enforce it, they might give different kind of outcomes to this. And so I think that we need to, even though we're running into details on this, we need to be very clear in our opinion on this, how there's just legal inconsistencies and how they're defining when you would actually be able to be okay with this. And there's major implications for that. You've actually started to develop and sink money into there at different phases.
And Commissioner Dorner, for the reason you just stated is exactly why I have such a problem with this being an omnibus piece of legislation. Because 19 text amendments are not created equal.
That's right.
Yep.
So with what's before us, I think this is the right position for us to take for all these reasons that you all are articulating for different ways. Okay, is there further discussion on the motion?
I agree with everything that's been said. And I was thinking also about what Mr. Warner had said, because that was my understanding of the vesting. But I do think, I think we need to put in there that they need to explain what type of application they're speaking about.
All right,
Because,
you have staff as well.
yeah, because it's not clear. It could be the application for almost anything.
Yep.
And that gives us another reason why we oppose it as drafted.
I
Thank you
think
for
that
that.
staff has heard enough of our discussion that they have a sense of how we would like to have it framed, the response framed. And so hopefully, Mr. Chairman will take a good look at that and other members to make sure that all items have been captured from our discussion.
Call for vote then?
I see a head nod. Is there any further discussion on this? Seeing none, I will call the roll. Commissioner Washington, I believe you made the motion.
I did. I vote aye.
Okay. And who seconded it? Vice Chair Bailey?
But I,
Commissioner Giraldo?
Vote aye.
Commissioner Dorner?
Did I?
I vote aye as well. The ayes have it 5-0. So thank you all. So let's go right to CB 17. Now, this is a standalone repeal of a text amendment. That may make us frame it a little bit differently in our heads because it is a standalone. I think some of the issues on this one are exactly what we just articulated. A little less cumbersome because it's not 19 of them. But you know, there was a long multi-year process that led to this text amendment. There was a lot of community process. You know, you've got the promises made, promises kept issue. Again, there's kind of an arbitrariness to this for me. Why this text amendment? Why those 19? Why not others? So even though it is a discrete text amendment, freeway, airport, discrete property, I'm carrying the same thoughts, feelings, reactions from this conversation into CB 17 as well. And I believe it makes sense for us to be consistent and to take the same position on this one that we have on the other ones. But I'm you know, open for discussion with you all about this as well.
Well, on this one, Mr. Chair, I just think that we need to be consistent with our previous position. Since we're being asked to consider it again.
So I'll just reiterate the point that I made earlier about the and/or. I think that's super confusing, and that's in this legislation as well. And that needs to be clear, like regardless of how we vote on this, I think that needs to be in the transmittal letter that you can't say unless an application for development is already filed and accepted and/or constructed. That just, there are two different points in the process. Like what is an application? And then is construction sufficient just to say like raising the lots and just like clearing the fields? Or does that actually mean like site construction and actually putting in structures? Just that the lack of consistency there, I think, is extremely confusing in terms of how you interpret the bill.
Yeah, I would agree that we align ourselves with the prior discussion.
Yeah, I mean, perhaps one way to do that is we can quite purposefully respond to the council with these two bills, you know,
Together.
tied together, right?
Yeah.
Right. Other commissioners have thoughts about this? Because I know that's a little bit different. And Commissioner Giraldo, I hear your point about the consistency with our previous position. And that's the problem with taking this one up separately. But again, because to Commissioner Dorner's point, even this one, the language in there is confusing. It's vague. It's not, doesn't give clear direction. So I'm inclined to have us take exactly the same position on this one. Any other reactions, thoughts? Is there a motion?
Should we
Mr.
put in there
Chair?
also how we voted before as well, just to be consistent with like the other report? Because they would know that we would be supportive of the idea based upon our prior vote, but opposing how it's drafted.
I think that's smart. I think we can say, and we even, to capture what you're saying with Commissioner Giraldo's point, we're mindful that this may read as inconsistent considering we opposed it before. But then we articulate everything we articulated in the previous discussion.
Yeah, I'm good with that, because I know I remember the discussion that we had on this, and we unanimously voted against that rezoning. So I just, for our own sake and our credibility, we do need to state that.
Okay, so let's put that loud and clear right up front that we recognize that inconsistency, and here's why we're moving the direction that we're doing, even if that may appear inconsistent in some ways. Director Checkley, you to comment on this?
No, just a question. I'll just wait to hear the motion because I'm not clear what you're doing, but I'll wait for the motion.
Okay. Commissioner Washington, you looked motion ready?
I was, yes, Mr. Chairman, I move that we oppose as drafted CB-17-2023 for incorporating the sentiments and discussion that we had on CB 12-2023, and also would ask that as appropriate, staff include in the transmittal the technical amendments that are outlined in staff's overview of the legislation.
I guess that's a second.
And
I do
we have a motion a second. Under discussion, I'm going to take direction to Director Checkley to make sure you're, Andre, you hear where we're going with this, and do you have any questions or concerns?
Yes, I do, and no, I don't.
Okay.
I'm clear, and I don't have any questions.
Excellent. All right, we have a motion by Commissioner Washington, a second by Vice Chair Bailey. Is there any discussion on the motion? Taking into account what Commissioner Giraldo said, which we will stay clear and upfront that we recognize that there may be some perceived inconsistency around this since we had unanimously opposed this in the past. But here's why we're taking the position that we're taking now, related to the process and the lack of clarity in the legislation. Okay. So no further discussion. I will call the roll. Commissioner Washington.
Aye.
Vice Chair Bailey.
But
Commissioner Giraldo.
Vote aye.
Commissioner Dorner.
Did I?
I vote aye as well. The ayes have it 5-0. Thanks, everybody. So we will now go on to CB 13. This, I'll turn it to Ms. Hightower. You can go through it.
Okay, thank you. CB 13, excuse me. This bill permanently repeals CB 69, which allowed former MXT zone properties outside of transit-oriented activity center-based zones, planned development-based zones, and the neighborhood conservation overlay zone to develop using the CGO regulations. This legislation raised substantial policy implications and amounted to a de facto changes in zoning that were not considered during the CMA, that is CB 69. And CB 13, 2023, as I mentioned, is repealing CB 69, 2022. The planning board voted to oppose CB 69, 2022 last year. CB 13 would allow properties to develop as recommended by the CMA. Staff recommends that the planning board vote to support CB 13, 2023.
Thank you, Ms. Hightower. If I can sort of frame this again from my perspective, while the staff supports the repeal, when I look at this and having had a lot of conversations with folks on all sides of this issue, this one feels like it's because there are some legitimate concerns around the impact of this in the development community. It feels like this is one where I think we would benefit from some more time to find some measure of compromise to address some of the credible concerns that at least I've heard. I don't have a strong opinion on this one, but I think, we are caught in a sort of a back and forth between effectively two factions of the council. And this feels like CB 69 may have been a bit of a overreaction to begin with, and the repeal of CB 69 feels like an overreaction the other way. So, I mean, what I think would be the healthiest for us is if we could take, even though staff is supporting the repeal, perhaps we could take no position, give us some more time to be involved in finding some kind of compromise to address some of the concerns. I don't have a strong opinion about that, but that's where I'm leaning, is a more moderate position on this so that we can be engaged. I froze on my screen. Can you hear me?
We can hear you. Just can't see your video.
He's frozen. Mr. Chairman's frozen.
But
But you can hear me okay? Okay, all right.
Oh, yeah.
So that's it. So I'm curious where you all are with this, if you've had a chance to dive in. Again, staff says support. I'm suggesting perhaps we take no position and sort of be a part of finding some measure of compromise. And I'm curious where you all are.
I would like to hear a greater explanation of staff for supporting it. And maybe Ms. Checkley could help us there.
I can,
Checkley?
Yes.
okay,
So
okay.
we were strongly opposed to this bill, the original bill, because of the effect it would have on Plan 2035. If you remember, help me out here, Ms. Hightower, I think it was the West Hyattsville
Yes, the draft West Side
Master
Spring.
Plan
Yes, ma'am.
and
That's correct.
sectional map amendment that you all had to send back to staff because of this bill. We, it majorly impacts a lot of areas, a lot of policy and direction of Plan 2035 and the individual sites. It would allow
Director Checkley, can I interrupt a second? Are you, Director Checkley, hold on 1 second. I just want to make sure that we're talking about the same bill, because my understanding, and maybe I'm wrong here, but I thought the one that was directly linked to West Hyattsville, I thought that wasn't CB. I thought that was CB 18.
Oh, then I may be mistaken.
No, CB 14 directly related to West Hyattsville. But this bill did impact, like Director Checkley mentioned, Plan 2035 centers. The bill originally drafted would have impacted all MXT zone properties. We worked with council staff to try to get it amended to exclude Plan 2035 centers to make it a little bit better, but the planning board and staff has always been opposed to this legislation because it would allow residentially zoned properties to develop as though they were, MXT zone properties to develop as if they were CGO zoned properties.
Right.
And those zones were only placed in and around our transit centers. And so
the change of staff, the change that staff recommend, this is my understanding, the change that you all very ably did with CB 69 was to exclude MXT that was in transit zones, broadly defined. So essentially, this is a much narrower version of a wholesale rezoning of MXT to CGO, because now it excludes all the sort of, essentially it's only MXT in suburban areas now. So this is a much more modest bill with a much more limited impact because of the negotiation you had with staff.
that is not my understanding. Let me see, can someone pull up? 'Cause
Okay.
like I said, I can't see on my screen the bill.
I guess the way I read it, it was kind of the legislation was like a zoning within a zoning process, which is kind of out
Yes.
of process, not to oversimplify, but, and that is something that we would not support or encourage. I mean, if there's something that needs to happen, there are ways to go about achieving that as opposed to a legislative zoning solution. Again, not to
Yes.
oversimplify, but that was kind of my takeaway from it, so.
Can you pull up the staff report on that one?
Mhm.
I think also just to point out
Yes.
why staff were opposed to the original bill is that it impacted over 7,000 properties in the county.
Yes.
So I could care less about making amends with the change from one county council to the other, like what they did before with the prior legislation, which is the total mess. So I support staff. I don't have any desire to make amends with bad things that they did in the past. I am fully supportive of this.
And from staff's perspective, it's really about the policy laid out in Plan 2035, and this goes against that policy.
Yeah,
And
a
that
couple
was
of
my
not here in the end of December when we had to extend the West Hyattsville plan because the county council had passed some legislation to just kind of undo some things. So we're in a point right now where the new county council is trying to go through and fix some things that were kind of problematic from the prior changes. So repealing this prior legislation with the current bill, I think is fine for me.
And I don't have a problem with trying to right size things. I just want to make sure in the attempt to right size, if you will, that we're not, not taking the time to ensure that the legislation does not promote any other unintended consequences. I mean, this is coming pretty fast and furious. I mean, when I went through the legislation, I mean, this is quick. It's what, January 5th. And it's not about whether it's the right thing to do or not the right thing to do, but let's make sure the right thing gets done and it gets done correctly.
Right. And that's my concern, because I'm agreeing with you, Commissioner Washington, and I'm agreeing with you, Commissioner Jordan. I don't have a problem with repealing what we thought was not such a great bill back then. What I do think is it's not clear, because I think Director Checkley, I'm pretty sure that what I was saying is the accurate thing, that there was already a compromise on this and it pulled MXT out of any of the urban areas, and this only applies to MXT in the suburban areas. I'm pretty sure that's accurate. And for me, this is about, let's find a compromise on this. Let's find some kind of ground on this piece. So that's why I'm more inclined to say, no position, and let's work for a compromise. But again, we may not be in that place because it's just so clear as day that we didn't like this bill when it was first passed. But is there any way, Director Checkley, to verify that? Because again, that makes a big difference for me if it applies to 7,000 MXT zones or if it's a bill with much limited effect.
No, it would apply to any property that was previously zoned MXT
Right.
and did not get the CGO zone.
This would apply
so
I'm sorry, Director Checkley.
No, go ahead, Ms. Hodges.
This would apply to approximately 7,093 properties, as mentioned in our staff report.
Right. That's what I wrote.
That yes, and that's that's the biggest concern is that the properties that were zoned MXT around our transit oriented zones received the CGO zoning to acknowledge what the goal around those centers are, the goals to. The properties that were MXT in other zones, in non-transit oriented zones, were given a different zone depending on where they were and what they were adjacent to, and through the metric the matrix, the CMA matrix.
Yep.
This would allow any property that was previously zoned, no matter where it is, to develop as though it were a property in one of our transit-oriented zones.
And I'll add on for context for the other commissioners. When this originally came, when the original bill, the CB 69 that's being contemplated to repeal right now, when that came before us last summer, so it hasn't been that long in terms of any sort of like impact taking effect. When they came before us before, staff was strongly opposed. The person who wrote the staff analysis was Chad Williams, who did all of our rezoning stuff, who's the best expert in the county probably, or one of the best experts on zoning and why we needed to do the rezoning. His first paragraph in there about the bill said, in summation, it would amount to changes in zoning that were not contemplated in the countywide map amendment, the CMA, and which would not be the result of comprehensive or piecemeal rezoning procedures. So that's his start of his opposition to there is pretty major. So I lean on the last part of what Chair Shapiro said and not caring about making amends with this. And I'm not concerned about the 7,093 affected parcels, because those were the ones who were affected originally. Those are the ones that were rezoned in a way that Mr. Williams and our staff would have said, not a good idea to do. We should consider the CMA. We should go through this in the proper zoning channels. That they were affected in a way that we would not have wanted and intensifying their usage. And then now we would just be removing that impact and going back to what we would have suggested all along if they had actually consulted with our experts in the planning processes.
Okay.
Yeah, I agree. I remember what Chad Williams when he argued on this, and I support staff on this.
Okay. Any further discussion on this? I'm okay. I mean, I'm misunderstanding a bit because I thought Director Chuckley that this was framed for me in a different way than what I'm hearing from you. So as I'm hearing it from you now, I'm aligning myself with Commissioner Dorner, Commissioner Giraldo. I just want to make sure we're not making a mistake about that, because I heard loud and clear that this was a compromised version of the repeal that's before us.
Chad Williams, who is everything that Mr. Dorner said he is actually on leave this week, but being Chad Williams, he is listening and can chime in if you would like him to.
Yes, please.
Chad, did you hear that?
Depends on whether he's like sitting on a beach drinking a Mai Tai or something like that.
He's not. He's not.
Okay, where is he? He just sent me something in the chat saying he could chime in.
He did.
Oh, maybe he's not able to, but I thought he said he could.
Let's give him his space if he can't figure this out. I mean, I'm hearing you, Director Chuckley, clear as day. I think I'm getting a sense of where the commissioners are, though I haven't heard from everybody. Don't have a strong opinion about this. We didn't like CB 69. Staff's position is to support the repeal, and I'm okay with following that. Taking the advice of staff on this one as well.
Yeah, I don't have any problem with the repeal. I guess, again, it just goes back to, is there any impact from anything in process that has not been considered?
I mean, that's the problem with this is that
Yeah.
the unintended consequences of this is that there very well are likely some quality developments that are real priorities for the county that are caught up in this because it is a shotgun approach. And so the intent behind CB 69 originally was to facilitate certain kinds of development in certain places that the current council doesn't like this approach to doing it. But so there are some quality development in some priority areas that are not going to be able to move forward if CB 69 is repealed.
Mr. Chairman, this is Chad Williams. I am here now. Can
Are you
everybody hear me okay?
Williams, we
I-
can hear you fine, and thank you for joining us on very short notice.
No problem, sir. My pleasure. But forgive me, I will not have my camera live for for this event. Um, so
That's
obviously,
simply because you don't want to evoke our envy, right?
yes, see the beach and waving palm trees and everything.
Exactly.
As I rush back for our lovely retirement celebration of a colleague this afternoon, which I will be present at. So I've heard the discussion, and there have been a lot of good points made. I think that when it comes to this bill in particular, the key is really listed on the second full paragraph on page 2 of the staff report. And the CMA, we were very careful to explain just how complicated the MXT and MUI properties outside of centers were with regard to the potential rezoning. As many of you recall, the kind of underlying rule of thumb of the CMA is that all properties will get the closest zone to what they had at that time, what they had today, being a couple years ago. Unfortunately, in the case of MXT and MUI outside of centers, there is no one single zone of the new zoning ordinance that comes close to these other zones. Historically, MXT and MUI have been generously very, very flexible, is how I will put it. That they end up with a lot of different types of things. Some of the property developers that came and testified on CB 69, for example, had approvals for 100% residential, and the MXT zone is supposed to be a mixed use zone. So it allows everything from 100% residential to 100% commercial with all kinds of mixing within. So the council's approved guide to new zones, which guided the CMA process, actually had a separate path for the MXT and MUI outside of centers that would have resulted in one of 7 zones based on a number of objective questions, including if there was an approval, what that approval had, whether it was predominantly residential or predominantly commercial, what the adjacent properties were. So the sum of it is, and one of the major staff concerns of CB 69 itself, is that there is no one single replacement zone for the MXT or MUI. And the mechanism of CB 69 designated the CGO zone as the replacement zone. And that still raised some comfort issues with staff. So the repeal of 69 from that perspective really helps clarify that issue and restores the CMA process. With regard to the compromise that you've talked about, Mr. Chairman, you are correct, and staff certainly appreciate the council's willingness to exclude the properties in the center-based zones. Those are the most important properties in the county per Plan 2035. They are exempt from CB 69. So those MXT and MUI properties did and would retain the center-based zone that was applied in the CMA. But we still have those 7,000 properties outside of centers. That is a lot of property, a lot of development areas that really it's affecting the nature of what I was talking about in terms of the background of there is no direct replacement zone. It's kind of designating a direct replacement zone after the fact. That has some concerns from various perspectives that I won't go into now. Looking at what the community has said, and I think some of what you may be alluding to, Mr. Chair, we certainly agree that there is some room for compromise. We do not necessarily think that, and obviously the board makes a final call, I will put it this way. I do not necessarily think that there's a need not to necessarily take any kind of action as the board on CB 13 for that, because as you rightfully mentioned, there is another bill that deals with a more global discussion of basically the bill that has the old zoning ordinance in effect in perpetuity, which will come up in a few minutes, CB 14. The most valid concern that we heard that was raised in the past year has dealt with uses and allowing property owners and business owners to access the uses of the prior zone. We already have plans for this month, for January, because this is a very pertinent issue, to go back and revisit the whole issue of uses and allowing access to the uses of the prior zones. I think our initial framing will be to recommend a certain time limit, because we do not want to see 2 codes in perpetuity, just as a preview of Ms. Hightower's discussion on 14. And I'll remain on the line for the rest of this session, just in case there are additional questions. But we already plan on addressing the issue of accessing uses. So to the extent that the discussions on this bill pertain to that question as well, I think we'll already be addressing that as part of a global revisitation. Honestly, the new ordinance staff, decision makers, we did not get uses quite right, and we know that, and we know we want to go back and address that issue.
No, this
So
is very
hopefully
helpful.
that provides some information.
No, Chad, it's very helpful for me, at least I can say it. And commissioners, you may have questions for Chad, for other staff members about this, but based on this, I feel like to just follow staff's position on this and to support the repeal is fine with me. Because I agree that the broader issue, which we're going to take up next, CB 77 repeal, they're linked in that way. So, okay, thank you. So do stay on the line. Are there any questions for staff? So my recommendation then would be a motion to support staff's position.
So moved.
Mr. Chair.
We have a
Second.
quick motion. All right,
Oh.
motion.
I didn't hear you.
We have a motion to support staff's position as drafted for us. Second by Commissioner Giraldo. Any discussion on the motion? Seeing none, I will call the roll. Commissioner Dorner,
Vote aye.
Commissioner Giraldo,
Vote aye.
Vice Chair Bailey,
Vote aye.
Commissioner Washington.
Vote aye.
I vote aye as well. The ayes have it 5-0. Thank you all. So we'll next move on to, and I think this will be a quick one, dare I say, CB 14, which is the bill that repeals CB 77. Ms. Hightower?
Yes, this bill, as you mentioned, Chair, repeals CB 77, which, as we were discussing before, permitted properties developed and constructed under the old zoning ordinance or have a pending application by April 2024 to continue to use the old zoning and subdivision ordinance regulations in perpetuity. The planning board has voted to oppose this bill in the past, as well as what Director Checkley mentioned, that because of this bill, the planning board remanded back to staff on December 15th the draft West Hydesville Queens Chapel sector plan and sectional map amendment. With all of that being said, staff recommends that the planning board vote to support CB 14 2023, which repeals CB 77 2022.
Thank you, Ms. Hightower. And let me just say, Commissioners, I just couldn't agree anymore with staff, and it would encourage us to strongly support the CB 14, which would repeal CB 77 for all the reasons articulated by staff. Ms. Hightower and in the report. But let me open it up for questions for staff.
No question.
Seeing none?
Chair.
Okay, seeing none, your motion.
Mr. Chairman, I move that we adopt the recommendation of staff and support CB-14-2023.
Second.
With motion by Commissioner Washington, second by Commissioner Giraldo. Any discussion on the motion? Seeing none, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Next, we have CB 15, 2023. This is the bill that repeals CB 78, 2022, the split zoning bill. And I'll turn it over to Ms. Hightower.
Yes, as you mentioned, Chair, this repeals CB 78, which permitted split zone properties to develop using higher intensity development regulations. It should be noted by the planning board that CB 78 only affected record lots that may have received more than one zone through the adoption of the CMA. The planning board voted to oppose CB 78, and staff recommends that the planning board vote to support CB 15, which would repeal CB 78, 2022.
Thank you, Ms. Hightower. Commissioners, on this one, I think that if we support the repeal and if the council goes through and repeals this, I think all it does is takes us back to the status quo. You know, there's still some issues that need to get worked out around this, but, you know, we can find some intelligent solutions and compromises on this, but I'm fully in support of CB 15 to repeal CB 78. But let me open it up for any thoughts, reactions, questions, discussion. Nothing? If there's no discussion on this, I'll look for a motion.
Mr. Chairman, I move that we accept the recommendation of staff and support CB-15-2023.
Second.
We have a motion by Commissioner Washington, a second by Commissioner Giraldo, I believe. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Next, we have CB 16, 2023. This is the bill that would repeal CB 79, 2023. Staff recommends support. Ms. Hightower, take it away. And I steal your thunder every time. I apologize.
No worries, Chairman. Of course, as you mentioned, this repeals CB 79, 2022, which reduced the lot coverage and green area requirements for undeveloped properties that were previously zoned I-1. Also, the bill would also permit, under the new zoning ordinance, distribution warehouses in the IE zone by right for properties that were undeveloped prior to April 1st, 2022. The planning board voted to oppose this CB 79 in the past. Therefore, staff recommends, for the above mentioned reasons, that the planning board vote to support CB 16, 2023 draft 2, which would repeal CB 79, 2022 draft 2. That concludes my presentation.
Thank you, Ms. Hightower. And in a nutshell, my read on this is that, for distribution warehouses to be allowed by right in the IH zone, which is the more intense industrial zone, makes all the sense in the world. But the IE zone is a more nuanced industrial zone. It's often adjacent to residential properties, where this would allow distribution warehouses in the IE zone, but it's by special exception. So anyhow, I think staff's position makes all the sense in the world to me. And see if there's any discussion from you all. No discussion, I'll look for a motion.
Mr. Chairman, I move that we accept the recommendation of staff and support CB-16-2023 draft 2.
Second.
Motion by Commissioner Washington, second by Commissioner Giraldo. Any discussion on the motion? Seeing none, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. And last but not least, we have CB 18.
Yes.
Hightower, take it away.
This bill repeals CB 97, 2022, which eliminated development standards for expedited transit-oriented development properties in the LTO zone. In common language, it allowed development regulations to be established through the approval of a detailed site plan. The planning board voted to oppose CB 97 when it was proposed. The bill undermines the critical goals of the new zoning ordinance. Staff recommends that the planning board vote to support CB 18, 2023, which would repeal CB 97, 2022. That concludes my presentation.
Thank you, Ms. Hightower. And I would just join with staff in saying that the repeal is important for me because the bill, the original bill, CB 97, essentially eviscerates the standards of the LTO zone. And the LTO zone was one of the most important zones in the new ordinance. TODs, transit-oriented development zones, should have standards. So I would support this repeal. It really was a shotgun approach and not particularly helpful. So any discussion on the motion? Seeing none, I would look for a motion.
Mr. Chairman, I move that we accept or adopt the recommendation of staff and support CB-18-2023.
Second.
Thank you. We have a motion by Commissioner Washington, second by Commissioner Giraldo. And now let me say, is there any discussion on this motion? Seeing none,
I'll
I'll
just say
call.
that it's nice.
Yep.
I'd say it's nice to be getting back to the new zoning ordinance and undoing a unproductive December. A very, I guess, productive in some ways, but unproductive for us. So, yeah.
Thank you. Agree. No further discussion on the motion. I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
I vote aye.
Vice Chair Bailey.
But I,
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Okay, that was a run. Ms. Hightower, thank you for all your work and the rest of your team. There's going to be more coming our way, but these are the 7 that are before us right now. Commissioner Washington, you have a comment?
Yes, I do. Before Ms. Hightower drops off, and thank you, Mr. Williams and Ms. Hightower, for your thoughtful analysis of these bills. As I was reading through these in preparation for today, it just kind of struck me that, and I know you probably, well, I don't know, but I assume you reviewed each bill in isolation or unique unto itself. And because they all deal with the zoning ordinance, if the team has not, I would ask that you all kind of take a holistic approach to see, because it felt for me that as I was reading one bill, the next bill I read, it's like, okay, well, that might contradict what I just read, or vice versa, that we take a real overarching look to make sure that that there's continuity and synchronicity in the legislation across the various bills. So.
Helpful comment. I appreciate that. And
Yes.
that works for me as well.
Thank you. Will do. Thank you.
Thank you, Ms. Hightower.
Great. Thanks again, team. So now we're moving on to items 4 on our, it's well after 11 o'clock. Okay. So we're on the consent agenda. Is there anyone here from the public who wishes to oppose the staff's recommendations on items 4A, B, or D, or are there any board members who wish to discuss any of these items? Seeing none, I would look for a motion.
motion to approve all items on the consent agenda, Mr. Chair.
Second.
We have a motion by Vice Chair Bailey, a second by Commissioner Washington. Any discussion on the motion? I'll call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. So we have 3 items on our regular agenda. And I'm going to take them in the following order. We're going to take up item 5, then item 7, and we'll conclude with item 6. So let us start with item 5. This is preliminary plan of subdivision 4-22043 Penzance Foxley Road. The attorney for the applicant is Mr. Lynch. We have Mr. Heath, who will give the staff presentation. I believe it'll be a fairly abbreviated presentation. I'll turn it over to Mr. Heath. Good to see you. Happy New Year, and take it away.
Thank you. Happy New Year. Good morning, Mr. Chair, members of the board. For the record, Antoine Heath with the subdivision section. Item 5 is a preliminary plan of subdivision 4-22043 Penzance Foxley Road, which proposes 1 parcel for the development of 162,500 square feet of industrial use. All information regarding this preliminary plan of subdivision has been stated in the staff report, and staff is recommending approval with conditions. If it is the will of the board to make a motion, this will conclude staff's presentation. But if you would like a more detailed presentation, I'm prepared to do that as well. Thank you.
Thank you, Mr. Heath. Before I turn to the applicant, commissioners, any questions for staff? Seeing none, I will turn to Mr. Lynch to see if you have anything you would like to add as well.
Good morning, Mr. Chairman, members of the Planning Board. For the record, Dan Lynch with the law firm McNamee Hosey. Let me begin by wishing everyone a happy new year. As Mr. Heath indicated, we're here today on a preliminary plan of subdivision for property located on Foxley Road. I have with me here today our development team, which is Josh Bowden and Jack Rushford, with the applicant, as well as Mary Gansert, our civil engineer, and Mike Lenhart, our traffic engineer. I will try to be as brief as Mr. Heath was. Again, we're proposing up to 162,500 square feet of industrial development on the subject property. As indicated on the aerial photo, the property is currently developed with a contractor storage yard, which is our intention to replace. My client and I have reviewed the technical staff report in this matter and are in concurrence with the findings. We've also had an opportunity to review the proposed conditions of approval. And as I previously indicated to Mr. Heath, I'll indicate to the board today, we're in a complete agreement with the staff recommended conditions. With that, again, I'm trying to keep it short. You already had a long morning. And if you have any questions, I'm here to answer those questions as well as any member of our development team. Thank you very much.
Thank you, Mr. Lynch. And I know there's a lot of work that goes on behind the scenes with all these cases. So thanks to you and to Mr. Heath for many conversations around this case. It comes to us with a fairly baked cake by the time it comes to us. So commissioners, any questions for the applicant? No questions for the applicant, nothing further for staff. Is there anyone from the public who wishes to speak on this matter? I don't think we have anybody. Nobody signed up to speak. So with that, I'll close this and turn to my commissioners. What is your pleasure on this case?
Mr. Chairman, I move that we adopt the findings of staff and approve preliminary plan 4-22043 and TCP 1-020-2022, along with the associated conditions as outlined in staff's report.
Second.
We've got a motion by Commissioner Washington, a second by Commissioner Giraldo. Is there any discussion on the motion? Seeing none, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Thank you, Mr. Lynch. Thank you, Mr. Heath. We'll now move on to item 7. This is a detailed site plan DSP 19057 LIW Ironworks. This was continued from December 8th, 2022. And there's a request for a further continuance, which staff is in agreement to, I believe. Let me turn it over to Chair Butler.
Excuse me, Mr. Chairman. Sorry for the record, James. I just wanted to make a quick statement here. This is actually Ms. Butler's last time before the planning board, and I just wanted to take the opportunity to state before everyone that we really appreciate all her hard work that she's done within the urban design section. I know her last day is going to be tomorrow. She's moving on to another position that is more in line with what she has stated she wanted to do in her career. So we're really excited for her. And but also, of course, sad for our team as well. But we're happy to see her move on to other things as well. Thank you.
Thank you for those kind words, and Ms. Butler, you will certainly be missed. And I hope the next thing that you're moving on to is rewarding, and that you're going to be an excellent contributor as you have been with us. So much appreciate all the work that you have done. Really.
Thank you. It's been a pleasure working with everybody, and I just want to say thank you for all the support that staff and the commissioner has, provided me in the last 2 years. And I guess with that, I'll just want to say thank you.
Thank you. Okay, take it away, Ms. Butler.
All right. Good morning, Mr. Chairman and members of the Planning Board. Happy New Year to you. For the record, my name is Tiara Butler with the Urban Design Section, and staff recommends that the Planning Board hearing date be moved from today, January 5th, 2023 to February 2nd, 2023, which is the new mandatory action limit date. And in conclusion, staff recommends that Planning Board approve the request for a continuance and schedule the application for Planning Board hearing date February 2nd, 2023.
Thank you, Ms. Butler. If there are no questions for staff, commissioners, let me turn to Ms. Scudder to see if she's anything she would like to add to this.
Good morning, Chairman Shapiro and members of the Planning Board. Happy New Year to all of you. It's good to see you all in the new year. I'm saddened to hear that Ms. Butler is leaving. It has been a pleasure working with you, Ms. Butler, and good luck with your future endeavors. With regard to the continuance request, yes, we understand that there's no opportunity for this case to be heard before February 2nd, But should something open up, we would ask that we be moved up to an earlier date if there's room at some point. But yes, I concur with everything that Ms. Butler just said, and we are okay with the February 2nd continuance date. Thank you.
Thank you, Ms. Scudder. Commissioners, any questions for the applicant related to the continuance request? Seeing none, what is your pleasure on the continuance request?
Mr. Chairman, I move that we accept the recommendation of staff and approve the request to continue DSP-19057 to February 2nd, 2023.
Second.
Got a motion by Commissioner Washington, a second by Commissioner Giraldo. Discussion on the motion. Seeing none, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
Vote aye.
Vice Chair Bailey.
But
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Thanks both. Thanks, Ms. Scudder and Ms.
Thank
Butler.
you.
Thank you again, and we'll see you in the next round in some way, shape, or form.
And
Yes.
Ms. Butler, I wish you well in your future endeavors. We will miss seeing you.
I do as well.
absolutely.
Thank you.
We will now move on to item 6, our final item. This is DSP 21001, Suffrage Point. Commissioners, we have received multiple requests to continue this item for a week. There are no legal issues or deficiencies which would require the planning board to continue the hearing of this matter. But the applicant has indicated that they're not opposed to a continuance for a period of a week. I just wanted to respond to a couple of items of note on the continuance request, if I may. One, the staff report for this matter was published on December 22nd, which is no less than 2 weeks prior to today's scheduled public hearing. So I just want to be clear that staff has done their job in terms of the publishing of the staff report. There were some other questions and concerns from folks in the community related to the submission of large files. Interested parties may submit large files by contacting the planning department. Staff has and will continue to work with parties to coordinate the receipt of those large files, as it has done in the past for other matters. I'm saying this to say that would not be a reason for this continuance, because staff has and will continue to provide that kind of support. There's no legal obligation to do so in advance of the hearing. All essential case-related matters are published to the planning board's website and the backup for each hearing, so things are being done by the book, as I'm repeating. The applicant, again, is not in opposition to the continuance. We will hear from the applicant, but that is my understanding. Now, there are several individuals who signed up, in addition to being in opposition, there's several individuals who signed up in favor of the project as well. So I just want to acknowledge them, because they also took time out to be here and to be able to, and to want to testify as well. So if we do approve this continuance, it impacts folks on both sides, and that's okay, that's appropriate. I still, as long as everyone's in agreement with this, I would still support the continuance, but I just want to note that it impacts folks in all sorts of ways. So let me, before I look for a motion for the board for the continuance, let me actually turn it over to staff, and then we'll hear from the applicants as well. So Ms. Kosak, you want to take it away for Britt and lay out what's before us related to continuance?
Yes, the item number 6, DSP 21001 Suffrage Point. It was scheduled for today. I believe the city of Hyattsville was requesting a postponement of the hearing until next week, January 12th. Staff has no opposition to that postponement, and that would be still within the 70-day action limit of the case. Again, staff is not requiring that postponement, but there's no opposition to that.
Thank you, Ms. Kosak. Commissioners, any questions for staff?
If we're gonna have another week to work on this, Ms. Kosak, some of my questions that I can tee up for you, so you have time to actually go and do them now. There's one mention in the report about how there weren't really many trees that needed to be preserved, because it's a parking lot right there. But my understanding is that part of this application involves the lower lots or the lower parcels that are going to be dedicated to the city. I don't know if any trees were cut down on those lots, which would be useful to know about if you can find out. And then there's some mention in the opposition exhibits and letters about cutting down trees prematurely. And I understand that this development is the lower half of the greater development that Wayland is doing. However, the upper half, there was trees that were removed earlier on, and there was sediment that ran down into that lower lot into other areas because I bike right through there and I go through there and I saw it. I would like to know a little bit more about how many trees were removed and if they're being replanted, particularly because I believe, I could be wrong on timing, but I believe they were actually removed prior to us hearing, so it was almost too late for us to do anything. So I want to know about any complaints that were lodged at DPI and how those were resolved and addressed, because to me, one of the aspects of the DSP is to be able to establish that any kind of like environmental harms or any sort of changes have been remedied and has been brought whole, basically, for this development. And I think that might be missed if we just say that there are no existing trees and we only look at like one part of this application, because it was almost like too late to do anything in the prior one. And since they split these parcels up, they are separate cases potentially, but it's part of the greater development that was brought forward here. So I would like to hear more information about those aspects if you could prepare those. And then I also want to know if you can work with Mr. Rivera later on just about the timing. I know that he's proffering an MOU with the city of Hyattsville, which isn't necessarily a requirement for those parcels, but I want to know about the timing of any kind of impacts on parcels C and D that are being given to Hyattsville, to making sure that there is stormwater management and mitigations that are being put in place, that those are happening early on, or just sort of like when they are. So I just want to know a little bit more about the details of how those will work. And I don't know if that's been established yet.
Thank you,
Okay,
Commissioner
noted.
Doerner.
I'll see what I can find out before next week then.
And Ms. Kozak, do you have any more information in terms of why other than why they DPI waived the stormwater management? Other than they're going to use fill?
Do you mean stormwater management or the floodplain waiver?
Floodplain, that's what I meant. I'm sorry, I misspoke.
Okay.
The floodplain.
I don't know those details off the top of my head, but that's another thing I can look into before next week. Yep.
Thank you, Ms. Kozak.
Ms. Coleman, you have a comment, Ms. Coleman?
I just wanted to make sure we didn't really get into the merits of the case, but just, we put forth some questions that we would like to see answered. That's fine, but as long as we're not getting into the merits and we're talking about the continuance.
Thank you, Ms. Coleman, for that course correction, and I agree with you. So for staff, you have a few items that we want flagged, but again, what's before us is the continuance. And let me turn to Mr. Rivera, who's representing the applicant. And again, just speaking directly to the continuance request, Mr. Rivera. Happy New Year, by the way.
Happy New Year, everybody. Good morning, Mr. Chairman, members of the board. Happy holidays. Hope everything goes well for all of us. And we're going to miss you, Ms. Butler, so good luck in all your future endeavors, as Tracy said. As you stated, Mr. Chairman, very succinctly, there is no legal reason or technical reason or procedural reason to continue the case. We are going to agree with the 1-week continuance. Although we were fully prepared to go forward today, we're happy to report that we've agreed with every conditions. But as to the continuance, we are in agreement so that the citizens in the city can have more time to review it. I realize it was over the holidays, but it was timely, as you said. So we will concur with that request to next Thursday. Thank you very much.
Thank you, Mr. Rivera. Commissioners, any questions for the applicant related to the continuance? Seeing none, then I would look for a motion from the board.
Mr. Chairman, I move that we continue DSP-21001 to Planning Board hearing date of January 12th, 2023.
Well, that got folks' attention.
A second.
So we have a motion, and is there a second? Commissioner Dorner, you seconded it?
Yeah, second.
So we have a motion and a second. Motion by Commissioner Washington, second by Commissioner Dorner. Is there any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
Vice Chair Bailey.
But I,
Commissioner Giraldo.
Vote aye.
I vote aye as well. The ayes have it 5-0 for the continuance. And just to note, so the hearing is being continued to January 12, 2023. Pursuant to planning board rules, there's no further notice required. So yes, but this will be on January 12th. Hold on one second for me, staff, commissioners. Thank you. Staff is reminding me to let folks in the community, public know that in addition to no further notice being required, anything that you have already submitted does not need to be resubmitted because that'll all be a part of the record. So, and Ms. Wolf, thank you for sharing your cat with us. I appreciate that.
You're always welcome.
So, is there anything else related to this matter? No? Thank you all very much. So that concludes all the items for today's agenda, folks. Mr. Hunt, is there any further business to come before the planning board today?
Mr. Chairman, there are no additional business items before the board today.
Seeing no further items, then without objection, folks, this meeting is adjourned. Thanks, everybody. Again, Happy New Year.
Happy New
Happy
Year.
New Year. Have a good day.
Great job.